Okay, we'll go ahead and call the Commerce Committee to order. St. Patrick's Day, March 17th. We'll go ahead and unsuspend the hearing on House Bill 2196. We have the neutrals today from the Department of Labor, Peter Brady. You're up, Peter.
Good afternoon, Mr. Chairman, and Acting Secretary Schultz is with us today, and I think she is going to start our testimony. So okay. I will pass to Acting Secretary Schultz.
Go ahead.
Thank you, Peter. Chairman, committee members, good morning. I'm Acting Secretary of Labor Amber Schultz. Thank you for the opportunity to appear before you today. I have also with me Deputy Secretaries Peter Brady and Brett Flashbarth, who are going to review KDOL's written testimony with you. But before we get started, I have just a few quick remarks. As you know, the Kansas Department of Labor, just like many other state labor agencies, is facing a myriad of complex, high priority, and competing challenges ranging from stabilizing legacy systems to paying legitimate claimants to preparing for a modernization project. The value I bring to KDOL is directly related to my technology and modernization experience and strategies, which span over 25 years in the government sector. These successful and transformative projects I've led places me in an optimal position to move KDOL and Kansas forward. Additionally, please know that we hear your frustrations and those of our fellow Kansans and employers. We are also frustrated, but undeniably dedicated to paying legitimate claimants and continuing to forge a path forward to a new, modernized system to support this facet of our state's social safety net. In my few short weeks at KDOL, I am deep diving into existing systems, and this is not an excuse, but a reality that the systems present challenges unseen in these recent times. As we continue this journey together, we value our partnership as we navigate these unprecedented events. I know at the end of the day, we all have the same vision of what success looks like in this space to service and earn back the trust of all Kansans. Efficient and effective services to Kansas and employers, an agile and resilient system that protects us from being in a similar position ever again, and clear and transparent communications with all of our stakeholders. With that, I'll turn it over to Secretary Brett Flashbarth.
Okay. Thank you, Acting Secretary. Mr. Chairman, I don't want to take too much of the focus away from the specific bill, and Mr. Brady is going to go through the department's position on all aspects of what's really a pretty extensive unemployment insurance package. We have been tracking the committee's hearings last couple of days. I did want to briefly touch base on a few topics that have come up where there might have been some confusion, or we want to make sure we can provide some information on just very briefly to the extent that there's been questions out there. The first is on the issue of fraud. There's been considerable conversation on what that means and what the different penalty components are. I want to point out a few things for the committee. Under existing Kansas law, there are two components to the fraud penalty. The first is the current 5-year disqualification period, which this legislation addresses, and I won't go into that particular component of it. Also, for clarification to the committee, I think this came up on Monday, perhaps, there's also a 25% financial penalty as well, in addition to the 5-year disqualification penalty. That 25% penalty was added at the same time in House Bill 2105 in 2013, as the penalty was extended from 1 year to 5 year. That penalty was actually the result of a federal law requirement. I think we've testified frequently that the Kansas law has to be in conformity and compliance with federal law. The feds passed provisions that said states had to enact at least a 15% fraud penalty in addition to whatever else they had on the books. Kansas chose to go higher, which was permissible under federal law. So there's those two components there. There's the 5-year and a 25% financial penalty on whatever the amount of fraudulent benefits that were obtained. Because again, the Fed said we had to do 15, but they didn't limit us if we wanted to go higher, which we did here in Kansas. In addition to that, there is also the possibility of someone committing fraud potentially being subject to criminal prosecution, depending on the specifics of the case and the dollar amounts involved and things of that nature. But I think there was a question for actually the revisor on that issue that I wanted to clear up. In addition, on fraud, there was quite a bit of conversation yesterday on what do other states do in this space. I think the proponents of the bill alluded to 2 years being common or 3 years. It is somewhat over the map. I would say The primary penalty amount for most states is 1 year, but it's not typically just stated that plainly. There's a lot of different formulas that are utilized. Some tie it to a benefit year. Some tie it to the number of weeks that were fraudulently obtained. There are a few states that do it where it's open-ended until you pay back the penalty, interest, and the fraudulently obtained amounts. But the vast majority are more centered around the 1 year, some going up to 104 weeks, depending on circumstances. And then again, a few states that are relative, again, open-ended, depending on when the claimant actually pays the money back. The United States Department of Labor annually publishes a comparison of state unemployment insurance laws, where you can actually go and look up what Kansas does in a particular space versus to what Colorado or Florida does. So we can certainly have our legislative team forward the link to that. It's online as well, if any members of the committee wanted to kind of just peruse and see how that issue is treated by other states. It's all over the map, but I would say 1 year is kind of the predominant one with some variance there. But we can certainly provide the online link to that, where you can get kind of a feel for how that particular issue is treated. The other thing on fraud, and I heard some of the testimony yesterday related to if it's an accident or if it's a mistake. Specifically, for there to be a fraud determination under KSA 44706G, there has to be knowing and intentional conduct in order to obtain benefits to which you would not otherwise be legally entitled to. So if someone makes a mistake and the department's adjudicating that correctly, that should not be a fraud determination. There should be evidence that the claimant knew they shouldn't receive the benefits, or that they knew they were providing information that was incorrect in an attempt to obtain benefits. There's a pretty significant appeals process with that. The first step is that an initial determination is made by a fraud examiner. The claimant would then have the opportunity to appeal that to the Office of Appeals, which is a more involved evidentiary hearing within the agency. And then the final administrative step would be that they could appeal to something called the Kansas Employment Security Board of Review. There was some testimony on that board yesterday, and that's also part of this legislative package. That at this time is a 3-person board appointed through a nominating committee that's advised by agency legal counsel. Beyond that, individuals would have the opportunity security board to the Kansas District Court. So there is more to a fraud determination just than someone making a mistake or getting benefits to which they would not be entitled. Now, I will tell you, it's a human process, okay? And when we went to that 5-year disqualification period, we did start getting a little bit of blowback from some district courts where there were cases that got through all those levels of administrative review, where the district court felt that basically a fraud determination that was appealed, we didn't have the goods, so to speak. So a few years back, we started looking a lot more carefully at our fraud unit to make sure that we really had good faith basis that the conduct related to that claim was knowing and intentional. And that's a never-ending process, because you don't want to hit someone with a fraud penalty where you don't have that clear evidentiary standard. You know, and we had a few that went through where it was like $380 and someone had failed to report holiday pay, for example. That's a little dicey as to whether that was actually knowing and intentional or someone making a good faith mistake because they got confused about how they were supposed to report that income. So that's just a little clarity on how fraud determinations work and kind of the national landscape of what that looked like. The next thing I want to touch on, there was some testimony related to how much funding we had left from previous modernization efforts. A big bucket of money that was used previously from the modernization efforts from about 2002, 2003 to 2011 was something called READ Act dollars, which is a component of the federal unemployment financing structure. I believe one of the proponents indicated that there's $9 million left. It's actually about $4.8 million of READ Act funding that's part of our available funds to push us forward in the modernization space. Real quick, there was some conversation related to the improper payment rate for Kansas. I don't really want to go too far down this rabbit hole. Improper payment rates for states is a subject of never-ending debate with both the states, USDOL, and OMB. Improper payment rates are derived from a quality assurance component of unemployment insurance called BAM, Benefit Accuracy Measurement. And what BAM does is it samples X number of paid claims and X number of paid claims after the fact, and it does a quality review to determine if those claims were paid correctly. There was a statement put out yesterday of Kansas being at 14% currently, and this is, a real problem. A couple pieces of data on that. That improper payment rate actually links back all the way to 2017, and it runs from a July to June period. Second of all, the biggest driver for Kansas and its improper payment rate, and for many states, is actually work search. And this is a big contention that the states have with USDOL, and USDOL actually knows this. I think they've had this discussion with OMB over the years. Unless you have the ability to contemporaneously monitor someone's work search when they're filing that weekly claim, there's not a lot a state can do to go back and really prevent that from a quality perspective. If a BAM person's looking at it, 4 months later and ask someone to verify if they look for work and they're not able to produce that. So one, you need the ability to contemporaneously kind of evaluate work search. Also, it incentivizes states to be less creative and less kind of forward thinking in their work search requirements, because the less restrictive you are on work search, the lower your work search improper payment rate really is. So this has been a long running discussion, but I would just caution in terms of trying to use BAM as an end all be all for how much money may be going out the door, because that improper payment rate is heavily tied to work search components, which don't have anything really to do with fraud or other areas. Doesn't mean it's not important, but I think the next time our improper payment rates published, you'll see it be lower. I would caution you to take too much with that either. BAM is really, the BAM manual itself is 241 pages long. You're really getting knee deep in UI nerdiness or policy wonk kind of things if you start really addressing BAM. It's important. We need to look at it, but simply taking that 14% and applying it across a large dollar figure, I don't think is going to give you the type of cohesive data point you're looking for when you're trying to analyze money that's going out the door. I don't want to waste up too much time on the committee's time, but if any members want to get into that in more detail, I'd be happy to address that with you. I am not a BAM expert per se, and I was unemployment director here for many years. It's a really detailed area that is part of the UI program. There was conversation on notifying employers on claims and the best way to go about doing that. I do want to point out existing statute does require employers to be notified on every single claim, right? So the statutory process is if a claim is filed, that employer is sent an employer notice, and then they have 10 days from the mailing date to respond to the claim. So there is notification sent to all employers when the claim is filed. Kansas and other states have actively pushed electronic use by employers in the last few years from something called SIDES. It's a national system where employers can receive an electronic notification to hopefully turn around that information cycle quicker. But in terms of calling employers on the initial claim, we do call employers on many of the cases for fact-finding purposes. Let's say I'm discharged, I give one story, my employer gives another story. It's not uncommon for staff to call both of us to ask additional follow-up questions on what actually took place with that job separation. But in terms of cold calling employers from the onset of the claim, the challenge we have on that aspect is you got to remember we have everything from mom and pop shops here in Kansas to Spirit Aerosystems and Cerner. Having updated specific contact information for who we're reaching out to determine employment status would be a bit of a logistical challenge. We do contact them after that initial employer response because as part of that, they have to provide that updated contact information, phone number, in case we have follow-up questions on what took place during that employment engagement. And then finally, there was conversation on the timeline related to a modernization project. I think one of the proponents of the bill indicated, it's an aggressive timeline, but work has been ongoing. There's been considerable project planning and RFP development and the keto required project steps. To be clear, we have not selected a vendor and we are not in active development. And if you're looking at the historical timeline for these projects of once you choose a IT methodology, once you choose a vendor, that's really when the clock is going to start. And you're looking at a historical 3, 4, 5, 6 year time period. I have chaired the national committee that assists the states in this space. I have never seen, and there's no known project that's been able to be completed in 18 months or under 2 years. It's just not something that's ever been done. I think Secretary Schultz indicated, her background and our mission is to try and drive that timeline down as much as possible. But in terms of indicating that we're steps at a certain point in time from work that's gone on in previous years. I wouldn't say that's accurate in that particular timeline. Mr. Brady can touch on this in his testimony. Is far more expedited than anything that's ever been done nationally previously. So I just want to clarify a few of those topics. I want to segue to Mr. Brady so he can respond again to the many sections of this bill, the agency's position on that, and then we'll obviously be available to answer any questions the committee may have. So with that, I'll turn it back over to Mr. Brady.
Okay. Thank you, Brett, and thank you, Chairman Olson and members of the committee for the opportunity to testify to this legislation. I want to say that, we're here to work with everybody. We want to ensure that we get a good product out the door. And with that, I'll say, there's a lot in this bill that we really do like. There's a few areas that we feel are policy decisions for the legislature, and then a few areas where we want to raise either operational or potential conformity concerns. You all have my written testimony in front of you, so in the interest of time, I'm just going to briefly hit some of the key points, and then as Brett said, we'll be available for questions afterwards. So with that, I'd like to start with the provisions that we strongly support. The first being adding tax withholding information to initial determinations. We think this will be critical information for claimants, especially claimants who have claimed for the first time and have not previously interacted with the unemployment system. Second, we strongly support the expansion of the Kansas Employment Security Board of Review. This is something that we brought to the table. As we've seen this massive influx of claims at the front end, the Employment Security Board of Review is the final appellate level. So if you think of just this volume of claims going through the process, this is the last stage in that process. So getting an expansion there is going to help us address any backlogs quicker as more and more claims get to that final appellate process. So we strongly support that provision. Additionally, we're very supportive of the improvements to the shared work program. This is a space that we've always felt is great for employers and keeping employees tied to their employer instead of entirely on the unemployment system. The expansions here, both in the weekly hours available and the program eligibility weeks, we strongly support. Additionally, we've done a lot of work in this space during the pandemic to market this better to employers and employees. And I believe some of those materials were attached to our testimony that was provided. The last component that I wanted to speak on that we strongly support is the changes for professional employer organizations. This was previously Senate Bill 27 in the last session, which I believe passed favorably out of this committee. The agency supported those provisions then, and as one of the proponents said yesterday, it eases the filing burden on those PEOs, it eases the process on our end, so we're strongly supportive of that. Next, I want to get to the pieces of this legislation that we are neutral on, and just want to raise a few comments for this body's consideration. I'll start with the first section of the bill, which is the creation of the Unemployment Compensation Improvement Council. The first concern we have in this space is the listing of the technical requirements in statute. There are many of these provisions and requirements that we do support having as part of our modernized system, but we do not believe it's good practice to explicitly list those in statute. An additional concern of the agency is that listing these requirements in statute now may put us in a difficult position in the future. For example, the last time our system was really built up in the 1970s, had we listed the technical requirements then, we would have made mainframe technology a likely requirement of the system. So we want to ensure that what we have in statute today is not just compatible for the next year or two, but for the future, so we can keep our system modernized and up to date with the most current technology. The second area that we just want to make sure that we raise a concern in is we share this committee's goal and the proponent's goal of modernizing as quickly as possible. And we want to ensure that the way in which this council is set up is going to allow us to do that and move aggressively. We really want to have the feedback and input of all stakeholders. We think that's crucial to this process. We just want to make sure that the end product for this section is something that allows the agency to move forward quickly. And then the final area of concern that we want to raise is that, and Brett alluded to this in his portion, there is a timeline deadline of December 31st, 2022. As Brett said, we're not aware of any state that has met a timeline that aggressive for full modernization. We absolutely expect to be well down the road into modernization at that point in time. but I don't think it's realistic to say that in 18-ish months from now, we'll be fully modernized. And the other concern particular to that provision is that as we go through the RFP process and vendors look at bidding on this project, having requirements like that, specifically the deadline, could potentially defer vendors from wanting to participate in this process, knowing that there's a deadline that may be very, very challenging to meet. The next provision that we're neutral on, but did want to raise a few points on, is the establishment of the My Reemployment Plan. This is the provision that requires the Secretary of Labor to work with the Secretary of Commerce on improved reemployment and work skills training. This section does increase the administrative workload for the agency, but the other point here is that this work is already being done largely by the Department of Commerce and the workforce centers, so it may be a little duplicative as it is written. We also have the RESCA program that we work with the Department of Commerce on to identify claimants that may need assistance getting back into the workforce before their benefits expire. So we wanted to raise that would add an additional administrative burden to the agency, but it is also duplicative of much of the work that is already going on today. And I know Brett has been involved in those initiatives in the past and can speak to that. The next provision that we're neutral on is the modification to the fraud penalty. We do think this is a step in the right direction, as that initial penalty is much more in line in this bill than the existing statute with what other states are doing. The concern we wanted to raise, and I believe one of the proponents raised this yesterday, was the outright ban on benefits after the second occurrence is very likely not in conformity with federal law, as there is no pathway for that claimant to become eligible for benefits in the future. So we would agree with that assessment that was stated yesterday in committee, that there's a likely conformity issue with that specific provision. And then the final provision that we are neutral on as well is the modification to weeks available in regular unemployment. This goes back to a threshold system, which is similar, but with slight changes to what we had prior to the pandemic. This is ultimately a decision for the legislature to make. The one note that we had is that the outcome of this would be less benefits would be available to some unemployed Kansans, but there would also be less of an impact on the unemployment trust fund. And then finally, Mr. Chairman, I'm going to speak briefly to a few of the provisions that we are opposed to in their current format, and just to raise some of the concerns that the agency has. The first being the adjustments to the timeliness for trust fund computations. This legislation has a section which requires us to produce some numbers on the trust fund solvency 120 days after the end of the state fiscal year. That is a little aggressive for all the processes that need to occur to calculate trust fund solvency. And those processes are listed out in our testimony. One suggestion that we have for this committee is in KSA 44701A, section F, there is already an annual certification of trust fund solvency that we are required to submit to the governor. And that is due by December 1st of each year. So we would recommend that any of the provisions in this section that the legislature would be interested in seeing each year be amended into that existing report, so we can keep our current timeline and then provide any additional information the legislature may be interested in. The next section I want to speak to is the new schedule for contributions from employers into the UI Trust Fund. Our only concern here is that, and you can see it in the graph in my testimony, during the lowest years of trust fund solvency, when the average high cost multiple is 0 or close to 0, this new system would bring in less contributions. What the impact of that would be is that it's possible employers would stay in the higher tax brackets associated with the lower average high cost multiple for a longer period of time, as it would likely take more time to build back up the solvency of the trust fund. So that is our concern specific to this provision. Several of the proponents testified about making the system more equitable for employers with different experience ratings. We do not have an issue with that goal or that component of what's being proposed. Our only concern here is just the level of contributions coming in at the lowest level of solvency. And then, Mr. Chairman, the final provision that we want to speak of is the transfer of funds into the Employment Security Fund and identification of improper payments. The reason we wanted to bring this to the committee's attention is because we believe as drafted, there is a possible conformity issue with federal law. Namely, the federal law on employment trust funds is very specific in what can come out of that trust fund account. And that is benefit payment to claimants and then reimbursement to employers who have paid more than they're supposed to in contributions. So we believe that as drafted, there's potential for money to be moved out of the trust fund at a later date. And we believe USDOL would likely raise a conformity concern with that provision. And Mr. Chairman, I'd like to thank you and the rest of the committee for hearing our lengthy testimony. We really understand that this is an important piece of legislation. We think there's a lot of good components to this bill, and we wanted to make sure that you were aware of any concerns that our agency had. Additionally, I wanted to let the committee know that the U.S. Department of Labor has conducted a conformity review of the original version of this bill, and we believe most of the conformity concerns were addressed in the amendments that occurred on the House side. But there were a lot of amendments that were added in. We have sent the amended version back to U.S. Department of Labor for an additional conformity review, especially to look at the items that I mentioned in my testimony. We have not heard back from them at this time, but we've asked them to escalate that review to ensure that whatever the final product is in full conformity with federal law. With that, Mr. Chairman, thank you again for your time. Myself and the rest of the members of our agency are available to stand for questions at the appropriate time.
Okay, questions? Senator Holscher.
Thank you, Mr. Chairman. I have a couple questions. First, I just want to go right back to that conformity review that you just mentioned, that an additional review has been asked based upon the amendments that have been made. And the transfer of funds is one of those areas where you are concerned there's a conformity issue. Were there other areas in here as you were going through, or is that the main one that you were concerned with the conformity issue?
Yes, Senator, that was probably the main one. The other issue that jumps out as very likely a conformity issue is with that modification to the fraud penalty, the lifetime ban after the second occurrence. And like I said, I think one of the proponents also flagged this yesterday. The fact that there would be no pathway back to benefits at any point in the future is where we see a likely conformity issue with federal law. Brett, is there anything else on the conformity front that jumped out to you?
No, and that's a great question, Senator. Not that we review, but I think we've noted many times, kind of reiterating this, USDOL looks at every piece of legislation nationwide. We've been trying to get our reviews expedited as much as possible because we know the importance of this bill. There's rarely a piece of UI legislation they don't offer some sort of comment on. And that doesn't mean that they're going to find a full-on conformity issue that they indicate would not be acceptable, but there might be other areas where they ask for clarification, or they comment that it's okay as it is, but if you decided to do this later on in the legislative process, we would have a problem. So to what Peter said, though, we don't see anything on our end, but that doesn't mean that they won't come back with something that we'll need to at least evaluate.
I have a couple more.
Go ahead.
And these questions are for Brett. As you were talking about the fraud penalties and different fraud issues, you mentioned something in regard to notification is sent to all employees when a claim is filed. And I think you started to say something about potential email notification.
Yeah, so there's kind of two issues. There's the fraud issue, and then there's just the standard claims process that's set forth in Kansas statute. All employers get notified of a claim when it's filed, and they have 10 days to respond under Kansas law. If they go beyond that, they can establish excusable neglect for whatever reason. The last several years, there's been a real move to, it's an integrity provision, actually. There's an entity called SIDES. It's collaboration between the states, United States Department of Labor, and the National Association of State Workforce Agencies, that for large employers or these third-party administrators like Mr. Oswald, who testified yesterday, he'd be a great person to talk about SIDES. It's a system-to-system exchange. So instead of getting an old-fashioned piece of mail, the employer gets an electronic notification that a claim has been filed, and then they can respond. The idea being, if we get quicker information, we can make quicker determinations and prevent money from going out the door, because everything in unemployment is tied to how fast you make the determination in normal times. The system's designed to get money out the door fast. We're judged on how fast we get the money out the door. And then for smaller employers, say you got a 20-person shop, there's a portion of SIDES that basically sends an email to a designated email address where the employer still gets it electronically and then they can respond electronically. So we've done campaigns in the past few years to try and get more and more folks signed up for that. I think we won an award from NASWA a couple of years ago. We had a pretty good improvement in terms of getting that. Employers who are on sides or the smaller version called e-response typically have pretty good, they prefer it. Some employers don't. Some employers love that paper. But that's been a point of emphasis nationwide for, gosh, 7-8 years.
Okay, and I had one more, if you would allow it.
Go ahead.
Okay. In a normal year, this is in regard to fraud itself, in a normal year, normal circumstances, can you give us an idea of how many cases of fraud that you see? And really what I'm thinking about is, of those cases, how many do we normally recoup? Obviously, this past year is going to be a little bit different. But I'm just trying to get the sense of what's normal.
Yeah, I think we'll have to come back with some specific data, but I can kind of give you the lay of the land at a high level, and then we'll get with the team and try and give you those more concrete data points, Senator. In a typical year, you're going to see less fraud than what we've seen here because the typical unemployment fraud is something called BYE. And if you drill down on that improper payment rate, you'll see BYE broken out as its own category. It's called benefit year earnings. That basically means you went on layoff at the factory, you were on layoff for 5 weeks, you returned to work and you thought, you know, that $488 a week was really nice in addition to what I'm making now, and you keep drawing. So you have benefit year earnings, but you're getting fraud amounts. In normalized years, and we can run some metrics for you, because I do think it's important to give you concrete information. The vast majority of claimants are doing it correctly, right? It's a relatively isolated number of fraud cases. You do see it. It's people get in financial trouble, people get greedy, any number of reasons. There's some more sophisticated fraud stuff even in normalized times. I don't want to go too much into that, but it's a lot of it built around things that are called like fictitious employer scams, where you set up a bogus company and try and file claims, things of that nature. The spike we saw this year was so much more indicated on this identity theft that we've talked about extensively in this committee and others. So in terms of the number of fraud cases, it's miles ahead of anything we've, even from a percentage basis, not even counting the number of claimants, from what we would see in a normal year. To your question on the kind of good old fashioned fraud, the BYE, the collection measures on that are actually really successful, especially once we were able to implement, I want to say we're in our 4th or 5th year, the Treasury Offset Program. Because it's a known fraudster, it's a known citizen that got the money. And then what we have the ability to do through the Federal Treasury Offset Program is for fraudulent debts, we can seize their federal tax returns. And if you would like, we can get you some number for TOPS collections since that program has been implemented. So, you know, everybody has to file a tax return. So sooner or later, we're going to be able to get a hold of that. So the collection efforts on that type of fraud is a lot more successful. With what we're seeing with this identity theft-based fraud, where it may be national actors, someone running a ring out of Florida, someone running a ring out of a foreign country, in terms of offsetting that against TOPS, that may not be as effective as a tool. What we're more focused on in that space is a couple different areas. I don't know how extensively I want to go into this in open session, but looking at the banking system to try and recoup those amounts is going to be a point of emphasis. So hopefully that answered your question. Sorry, I was a little long-winded.
Great, thank you.
Senator Stuffin.
Thank you. And you started to touch on some of my issues. You know, we've spent a lot of time yesterday and even in today talking about this sunny day fraud. And that's really not what's getting the headlines. That's not what's brought this animal down. It's felonious theft. And we do need to have some understanding of how this has transpired, what's being done to remedy it, what our options are moving forward to prevent this. Because my ultimate goal is to see 0% of this felony theft go on. And I'm pretty convinced we can't do it with the current system or under the current circumstances. But I don't know if it needs to be done in a closed session or what scenario, but we need to have a better understanding of what has brought this thing utterly to its knees. And that hasn't been the sunny day petty theft. Help us understand how this went on, the process that it went on, and what our options are for having a better understanding of it, please.
Yeah, thank you, Senator. And I will address that very briefly because I do want to make sure, and again, I don't want to infringe on your prerogative, Mr. Chair. We do want to make sure we're available to answer questions on this bill because it is pretty substantive. But I'll touch on fraud real quick to your point, Mr. Vice Chair, and that is what the kind of game changer we saw was really the identity theft. And I think we've testified on this extensively, where typical fraud, it's fairly easy to catch in the sense of we do run cross matches. We run cross matches with Social Security Agency. We run cross matches on new hire data. We run cross matches on quarterly wage reports. So if you just return to work and don't report it, we're going to see you pop up on a quarterly wage match and say, hey, you're still working. Why are you claiming unemployment benefits? What really was the distinction here was this identity theft base where fraudsters, sophisticated in nature, had access to key parts of unlocking the door for a claim, so to speak, in terms of Social Security number, date of birth, and name. In terms of what we're doing about it at a high level, because I don't want to go into too much detail and take us off the rails here, it's really a couple different components. It's preventing it up front, which is a challenge. We have adapted. We've implemented that ID verification, multi-factor authentication. I think even proponents of the bill have indicated that they're seeing the results of that being implemented. The second thing is, to the extent possible, prosecution. And that is an active through line we're involved with as well. I'm not going to go into active investigations too clearly, but we are in regular communication and working this issue with state and federal law enforcement partners. Okay. And then the third component would be recoupment, which again, there's active conversations going on in terms of this is a different type of fraud. You know, the question Senator just asked, what are the newer mechanisms we're going to have to try and recoup this money as opposed to previous techniques, which may not be applicable in this situation. I think the next evolution of this, though, is states like Kansas are adapting in terms of ID verification and other tools that maybe we didn't have in place. Where are the fraudsters going to go now? And we're already seeing that. We did quite a bit of public awareness last week on the issue of bogus websites and Facebook sites. We're seeing those pop up right now where fraudsters are putting out there a Facebook page that purports to be the Kansas Department of Labor or the Missouri Department of Labor and asking folks to supply personally identified information, banking, financial institutions. So I think that it's going to be a constant battle for us to try and identify with our national partners what are these emerging trends, and then do we have the appropriate safeguards and tools in place to try and prevent it?
Have any follow-up? Nope. Couple from Senator Schwab. Okay, Senator Holland.
I'm just curious, just real quick thing, Mr. Chairman. Yeah, so Brett, just as a follow-up to that, is like DHS or some of the federal agencies getting involved with this from a cybersecurity issue, working with you guys? I mean, how are you able to keep on top of best practices for going after these folks?
Yeah, that's a great question. So we talked about a lot. A really great partner and resource is that National Association of State Workforces Agencies Integrity Center. They're heavily funded through the United States Department of Labor. They have regional representatives. They have state liaisons. Our state liaison's a former fraud official from Maryland, for example. She's incredibly knowledgeable. We're in regular communication with her. We have been engaged with FBI cybersecurity officials in terms of some of the investigations that we're trying to look into of fraud that may have been committed in Kansas. I don't want to go too far down that road again in open session, but I think there is a little bit more of a national view on this. I don't think we saw quite the national cohesive effort from a national law enforcement perspective earlier in the kind of pandemic. But we have been involved with some calls and some communications that make me feel a little more optimistic that there is a bit of a more coordinated strategy at the federal law enforcement level in terms of trying to tackle this issue.
Mr. Schwab.
Thank you, Mr. Chairman. I just wanted to point out that I agree with Senator Stephan on the focus on the fraud, because what we're being asked to do here is make a decision on a bill to change those provisions of the employment security law, yet we haven't solved the problem at hand. So, and I don't mean to keep going back to that, but we have to plug that hole before we fill this back up with money, because the same thing's going to happen again. We've got to figure that out and solve that first and foremost, I think, before we can make an educated decision on how to proceed going forward.
Can you answer
Yeah,
that?
I would love for you to share whatever you're able to share in an open session like this. I understand that there's details that you really can't, but I really think that the question, the public question is, just over a year ago, we were sitting with over $1 billion, I believe, in our unemployment insurance fund. What happened to that, and how can we make any decision to proceed without knowing that we have fixed the issues?
Yeah, thank you, Senator. And again, I don't want to go too far afield here because there are numerous positions of this bill we want to make sure we can respond to. So the issue of fraud is obviously something that there's been extensive work done already. There has been a legislative post-audit study commissioned on this. I'm sure most of you have reviewed that legislative post-audit study. We also provided a fairly lengthy and detailed response in terms of our own fraud calculations and how much of the money from the trust fund is attributable potentially to fraud, specifically regular benefit fraud. In addition, LPA is continuing with that audit, and we will be working with them and the legislature on providing information on how much fraud was out there. There's also a substantial number of people that have been out of work the last year, and that's why state UI trust funds all over the country are seeing diminished levels. As we pointed out, many states were in a borrowing position early on in the pandemic due to depletion of their trust funds. So there has been there's a reason why so many people are calling your offices for assistance, because there's still a lot of people that need help out there, and there's a lot of money that needs to be paid out legitimately. In terms of the fraud prevention, again, I think we've testified on this, but I'll repeat it. We have implemented the ID theft and multi-factor verification. We have seen that paying dividends. I think, again, even the proponents of the bill have indicated a drop in fraudulent claims, ID theft claims they're being presented. We're continuing to push that work forward. We're also utilizing the fraud application through Google that our team is working through. That has paid dividends already in terms of our ability to quickly process pay files while determining if we think that they're clean claims or whether they're potentially fraudulent claims. And then it's a daily process of what additional steps can we take. That includes, refining our operations and possible reorganization to make sure we're working smarter, not harder, adding additional fraud staff, public awareness campaigns like we did last week in terms of the next evolution of bogus websites. So fraud is a multi-tiered assault on the system that's being put upon us here in Kansas Department of Labor, and our response to that has to be multi-tiered. And it's not a static situation where we can say we've got it beat and we're good to go going forward. It's us every day evaluating potential threats to the system and then seeing what we need to do to respond. So we've put numerous initiatives in place that I've discussed, and I would be stunned if we don't utilize some additional strategies in the coming months, or try and deploy some additional best practices that we may pick up from other states. One of the things we picked up was, trying to block certain banks that may be associated with fraudulent activity. So we've kind of spiked the football and we're done. We're going to be looking at this every single day to make sure the money going out the door is being paid correctly.
Got a follow-up, or Senator Holland? Oh, Senator Tyson?
Thank you, Mr. Chairman, and thank you, Mr. Acting Secretary. I appreciate the work you guys are doing. I know this summer we did have a closed-door session for you to be able to give us and answer some of the questions that the senator might have. I don't know if that would be something that the committee would consider, Mr. Chairman.
We'd have to do an executive session, and there'd have to be a motion. We could do that.
No, I meant to plan for it. I didn't mean
Yeah.
today.
Yeah, no, I know. We
Thank you.
couldn't do it today.
Thank you.
I'll get with the reviser, and we'll look for the correct way to do that. I've set in the post-audit closed-door sessions, and so I definitely understand where you're going with that. Senator Holland.
Yeah, Senator, we would definitely be willing to come back and do that, Senator, and be a little bit more freely speaking on some of these initiatives. So we would, from the department's perspective, just let us know, and we definitely would put something specific together for whatever the very specific questions you may have in that space. I do want to note, Senator, I'm back to my day job of Deputy Secretary, and Acting Secretary Schultz is on the call, so I'm no longer Acting Secretary. I'm back to my normal job. So Acting Secretary Schultz, my boss, is on the call as well. I just want to make sure I point that out.
Senator Holland, you got the floor.
Thank you, Brett. Hey, thank you, Mr. Chairman. So, Brett, a couple additional questions kind of popped in my mind now because I think there's a lot of interest, particularly on the committee, on this ID theft portion of the fraud. So let's kind of go down this path a little bit. I just want to talk about some data points here, whatever you want to call it, for the committee. So when we talk about this ID theft, obviously we've seen millions and millions of dollars drained out of the UI system. UI theft, what proportion of that just can you give me as far as the proportion of the monies that have left the system specifically because of ID theft? Is it 30%, 20%, 50%? How much would you say?
I'm putting just kind of some guesswork out here, and Peter, or Secretary Schultz, feel free to contradict me if you think appropriate. I would say for the fraud we have seen in the last year since the start of the pandemic, Senator, I would estimate that the vast majority of fraudulent payments were the direct result of identity theft. That's my personal opinion on that. It doesn't mean run-of-the-mill fraud still isn't taking place, but in terms of, I think you can see that through once we did go live with that ID verification, the millions of bot attempts that we were seeing trying to intrude on the systems indicates the scale of those outside kind of sophisticated attempts. So my position would be that the vast majority of fraudulent payments that we've seen, both in Kansas and nationwide, are the direct result of sophisticated ID theft fraud as opposed to other types of fraudulent attempts. And Peter, would you disagree with that statement?
No, I absolutely agree with what you said.
Yeah, so Brett, that's not quite what I'm asking. What I'm talking about is when you look at total dollars going out of the UI system, okay, total payments going out, what portion of those dollars is specifically because of the identity theft?
Yeah, so it's going to be minority. I think we can pull that together pretty quickly because we're going to be able to show payouts, and then we obviously promulgated our estimate of fraud the same week the legislative post audit did, and I think our figure was put at 290 million. So we can certainly do a back of the envelope calculation in terms of total payouts, which I believe are over $3 billion now, and then our own frost estimates. So probably roughly about 10%.
Okay, and so my question would be then is that have the employers on the UI, on the identity theft, have the employers who've been hit by this, or at least have been credited their accounts, have you guys been able to basically, do you have a process of quote unquote holding them harmless? I mean, are they able then to promptly get with you? Well, I mean, obviously they're not promptly getting to you, you would have knocked it off up front. But I mean, where this has occurred, are you finding that you have mechanisms in place to give those employers credit so that they in fact are not getting hit with that, once the stuff occurs?
Yeah, that's a great question, Senator. And Peter, you can jump in here if I misstate something. Our existing interpretation of the Kansas Employment Security Law, we feel, allows us to hold employers harmless when the monies have been paid fraudulently, okay? This bill has language that I think we're neutral on. I think this bill has language that makes that a little bit more explicit. So we're fine with it. We don't have any issue with that. We think the current law has that in there, but the language that's been proposed puts it out a little bit more upfront. So we do feel there's existing structures in place that employers who are victims of fraud are held harmless in terms of their experience, rating account, and their charges. Now, in fairness, I think the proponents talked about this. If you do have fraud coming out of the system, at the end of the day, that's going to be borne by the entire contributing employer community and the trust fund overall. So those dollars are going to have to be recouped.
And I guess that's my final question, Mr. Chairman, and I will be quiet and go away. But my question would be then so for those actual dollars then that have gotten paid out, we know obviously they're fraudulent. What is the completing the loop of that? How are those dollars somehow accounted for back into the UI system? How is that made up? How do we address that loss?
Yeah, it's made up by the existing contribution structure. The trust fund, the analogy I always use is kind of like the beast has to be fed. So there's certain marks we're going to have to hit in terms of contributions that go in that are dictated by that existing rate structure. So employers are going to see changes in their rate, up, down, whatever, depending on whatever policy decision we go on towards the taxing structure and the payouts and the amounts that we have to replenish into the trust fund.
And has there been
the
any
trust-
talk on, say, through the America Cares Act, anything at the federal level where the feds may step in and basically help the states basically replenish those dollars specifically lost due to the ID theft, or is there any talk on that, or is this going to be left to the states?
My understanding is that there's nothing specifically enumerated in the legislation calling for funds to be directed towards trust funds, but there's a possibility, there's some leeway there in terms of the federal dollars made available. Peter, is that correct?
Yeah, Brett's correct. There's nothing specific in that legislation. I would note that the National Association of State Workforce Agencies that Brett referenced earlier is very actively pursuing that with Congress, but there's nothing specific in the most recent stimulus to that point.
Thank you.
Okay, I've got a question. One of the opponents of the bill we heard, and I've had a case myself where someone has got on the fraud list. We don't think they should be on there. And we'd heard that in testimony, what is the remedy to get off the fraud list? I mean, is there a way to get off that list?
That is an outstanding question. So when we talk about issues that are possible impediments to getting folks paid and why this is such a difficult challenge, there's any number of reasons. It's perhaps our challenge in coding and implementing the most recent federal extensions in our older system. It's perhaps individual issues associated with the claim. There is a subset of claimants. It's a population who have been, looks like you lost a piece of paper there, Mr. Chairman, who have been caught up in this identity theft pandemic that has hit the states and been imposed upon us and our citizens. So there are folks who have been possibly tagged as fraud that then we have to resolve that issue and make sure that there's a clear pathway for them to get paid. There is a process for that. The tools we're implementing are helping on that greatly. The ID verification, utilizing that to validate that this is in fact, Rob Olson and not some imposter, and that if you need the benefits now, we have the ability to pay that. We've had several meetings on that in the last week in terms of what we can do to expedite that process and say with certainty that the good faith claimants are in fact who they say they are and not fraudsters, thus lifting that barrier for payment. Quite frankly, a lot of the constituent calls we've gotten have touched on that very issue. So we're engaged with both our internal staff and external partners in terms of trying to reduce that determination cycle to clear those folks and make sure we can get them the benefits. Peter, do you want to add anything on where we're at from a business process perspective?
Yeah, just two quick points to add to what Brett was saying. The first I'd say is that there are, identity theft is the predominant form of fraud that we're seeing, but that's not to say that it's the only form we're seeing. Something we saw across the nation and attempted in Kansas is something referred to as claim hijacking. We put out notices in the past, you may have seen them, and it's what's being attempted with these fraudulent Facebook pages that we talked about last week is there's fraudulent actors out there that are attempting to impersonate departments of labor across the country in order to get claimants to give them their login information. What they do with that login information is then they attempt to get into that individual's claim, change their password so they can't get back in, and then redirect the funds that that individual is entitled to and would be getting. As Brett said earlier this year, we implemented the multi-factor authentication tool. That drastically reduces the risks associated with claim hijacking. Another quick note on resolving issues in which a claimant might be flagged for fraud. Even though identity theft is the predominant form of fraud, we're also seeing more traditional fraud, specifically in the PUA program, where an individual, for example, could be who they say they are, but they have attempted to submit fraudulent documentation or forged documentation to create an entitlement for that benefit. In those cases, it's not a matter of just verifying their identity and they are who they say they are. It involves an investigation in that case to determine if that individual knowingly and willingly attempted to defraud the system or obtain benefits in a fraudulent manner. And those investigations do take more time than the simple verification of an individual's identification. So I think it's been touched on a lot throughout this hearing. The fraud issue is immensely complicated. We're putting a lot more resources into that space to get the legitimate claimants out of that space and paid. Because another component to this too is there are many individuals who would have been victimized by identity theft early on in the pandemic. We would have stopped that claim as potentially fraudulent. And now that individual may need benefits that they're eligible for. So we need to ensure that we take the fraud suspense off that, make sure everything's updated for that claimant so they can start filing for benefits they're eligible for. Does that address your question, Mr. Chairman?
Does, also, in theory, if we're building a brand-new car, system, whatever you want to call it, it's going to be modern, robust, it's going to have a lot of automatic triggers that we don't have in place that should stop this fraud, right? I mean, there's systems out there that I have to believe that probably had very little fraud because they're a more modern system with automatic triggers. And where ours is kind of dated, we'll say that, we can't put them in. Isn't that the reason, one of the reasons why we need to move forward with this modern system? It'll be what stops the fraud.
There's probably two main components of that in terms of how a modern system helps you fare a little better. First is most of these systems aren't going to come off the shelf with identity verification solutions, but a more modernized systems allows the addition of those tools and the implementation of those applications or external software to be implemented easier. One of the challenges we had in introducing ID verification, multi-factor authentication is we're stapling that onto our old and already complex infrastructure, and it's very delicate and it's not an easy process. So a modernized system is going to give you the ability to add that sort of functionality in a much smoother way. The second part of it is the case management process. The demos I've done with Mississippi or Idaho or Missouri or some of these systems is it's so much more user educator, customer service, appeal referee, whatever your role is with the agency in terms of how the work can be tracked, assigned, closed out, where we probably should really do a demonstration for the committee and others at some point in time in terms of what our CSRs have to do and what our fraud investigators have to do currently, the number of screens they're having to pull up and work through, using Excel spreadsheets, things of that nature, as opposed to having really dynamic workflows where a case can be assigned to an adjudicator. They've got the relevant documentation up on the screen. They can make the call, close it out, it's tracked. So your point is well made, Senator, that a modernized system will increase the ability of the state to respond to future versions of fraud as it comes down the pike.
Okay, further questions? Okay, well, thanks for coming, we appreciate it. What we're gonna do is, I'm gonna see if we wanna work a bill, but I think what we'll do is, the next couple days and over the weekend, I ask everybody that's got an amendment to get with Chuck or the revisers to get your amendment done. And on Monday, we start working the bill. And, I'm going to schedule a couple bills for hearings on Tuesday. But, this takes first priority. We'll finish this bill if it takes until Tuesday and we get it out, then we'll move on with the rest of our schedule of our work. But it's kind of a little different path. I know I stated we're going to go into working the bill. I just think we probably ought to give Chuck a couple days because I think there's about 15 amendments or 10 to 15. And so, let's do that. And so we'll close the hearing on 2196, House Bill 2196. The bill that I was consider working is 161. It's the Amazon bill. I'd consider working it as long as we don't put on the FedEx amendment to expand the weight. I think, we ought to try it before we expand it. So on that, if there's someone that wants to make a motion on 161 to pass it out, I would. Sure. Yeah, go ahead.
Thank you, Mr. Chairman. Is this the exact same bill that passed out of Commerce last year? Or does it
Yes.
have a few changes?
I believe so. Chuck, could you give us an update?
Certainly, Chairman, members of the committee. So with respect to Senate Bill 161, as the committee will recall, this is a bill that allows for personal delivery devices to be used. Probably one of the main aspects of the bill is that these devices are not to be considered motor vehicles. They're exempt from Kansas motor vehicle law. There are a number of things that are required with respect to these devices. And I guess another kind of component of the bill is that they're essentially treated as pedestrians for purposes of traffic laws. So as far as whether this is similar to the bill on the other side, I don't believe there are any differences that I can recall with respect to the two bills.
This is the same bill as last year.
I believe so. I would have to go back and compare them, but I don't recall any, at least not any significant differences between this year's bill and last year's.
Okay. Senator Holland?
Mr. Chairman, a question for Charles talk to me about what's the weight limitations, and was there some talk about raising the weight of the pedestrians up to 500 pounds or something, or where do we stand with weights on this thing?
So, Senator, the weight limitation, I'm trying to find it here in the bill. I think it was 150 pounds, if I remember correctly. Not including cargo. And I'm trying to find where that is stated in the bill here. But I think FedEx was interested in increasing that, limit, as you noted. So that was something from them. I think Amazon, the limit was lower.
Yeah, if you look at the fiscal note, it says not to exceed 150 pounds.
Okay, so Mr. Chairman, the FedEx references to FedEx wants to actually raise the weight of the pedestrian.
Yeah, I probably wouldn't. I do have the right in my rules to refuse amendments that I don't deem. I probably wouldn't. If that amendment was brought forward, I wouldn't allow it. But just kill the bill.
You may not allow it, Mr. Chairman. Obviously, if it went to the floor, somebody else could throw it on.
Well, it'll be the wisdom of the body.
Yes, sir. Thank you.
Senator Stephan.
Thank you. Could I have a refresher on the verbiage in the bill, which I unfortunately didn't bring with me, in regards to Amazon's liability for these things?
Senator, liability is limited. Liability is limited to, and I'm trying to find that provision. I think it's $100,000. Yeah, so that is on lines 30 through 33 of the bill, and that's on page 2. Page 2 of the bill, lines 30 to 33. Liability is limited to, you have to have an insurance policy that covers at least $100,000 for damages. So there's no specific liability limitation. I apologize, that's not correct. It's just you have to maintain an insurance policy that includes general liability coverage of at least that amount.
If you guys want to wait on this bill, we can. It's just, I think the lobbyist told me he talked to everybody, and so. Okay. Do we have a motion? Okay, you moved to pass it
Chairman?
on. Yes.
Dylan just sent me a note that the bill states the weight limit is 1,500 pounds. And that, I'm trying to find that 150-pound limit. That if that's true, that is an error. You know, Amazon's was, their request was for 150 pounds. So I'm trying to find that and make sure that isn't incorrect, and we don't need a technical amendment to fix that.
Well, the fiscal note I have says 150 pounds, so.
Yeah, here we go. So I direct the committee's attention to line 17 through 21 of the bill on the first page, where it talks about does not exceed 150 pounds excluding cargo. So that should be the weight limit.
Feel comfortable with 150 pounds?
Dylan sent me another note here.
Senator O'Shea, you got something to say?
Yeah.
Go ahead.
Thank you, Mr. Chair. If I recall correctly, too, the municipalities had concerns with this previous year, but were able to work in their, were able to work out what their concerns were. Correct?
My understanding is, and, you know, Kevin can come up and explain, I don't know. But the municipalities, my understanding, the league negotiated the original bill of last year. FedEx come in, and I don't remember what their weight increase they were asking for. And the league said they were uncomfortable with the increased weight from over what they'd negotiated from last year. So that's what I remember as the league not supporting the bill. They thought the weight was too heavy. You know, they were comfortable with the 150, or they could live with the 150, but they did not want to go higher than that. So that's my recollection. We got a motion on the bill. Do we have a second? Okay, so now we have an amendment.
Thank you. I would like to propose an amendment based on my experience in the oil field. Carrying a $100,000 policy would be something nobody would do. And these things are going to be around a lot of people. They're moving. They're going to be around vehicles, kids, so on and so forth. I think the insurance policy is way too low. I think that I propose an amendment. We raise that to $1 million in line with other sectors.
Okay, do we have wait, let me think, it's been a while. Got a motion and a second, on the original bill. So you're making a substitute to add that in. Okay, let me think. Yes, Senator Dahl?
I'd sure like to see the senator's amendment written down before I voted on it. I'd like to read it. I think I gather what you're saying, but I'd feel more comfortable if we did this tomorrow.
Let's just carry it over until tomorrow.
Yeah.
And then this will give a chance to get everybody a copy of the bill, okay? Okay, so we'll go ahead and just suspend work on the bill and carry it over till tomorrow. And this meeting's